Hi, I'm Casey O'Connell with Halloran and Sage's Business Transactions Group, and I'm here with Ann Catino from our environmental group, and we're here today to talk about the Transfer Act. The Transfer Act has been around in Connecticut law, and it's kind of a unique creature of Connecticut law pertaining to transfers of establishments. And it has been sort of maligned over the years, and there has been a push for reform of the Transfer Act, which has finally gone through. And I believe that a lot of people are under the impression that the Transfer Act is in a sunset phase and is going away. So, Ann, can you tell us a little bit about what the Transfer Act is and why people may be excited to see it reformed and or go away?
Sure. Thank you, Casey. As Casey indicated, I'm Ann Catino. I've been practicing environmental law for over 30 years. And during my entire career, we've transferred certain types of properties and businesses pursuant to the Connecticut Transfer Act. And it has been a bit of a unique law in Connecticut, unlike other states. And there's been a lot of fussing about it, and people haven't liked it, as it may be perceived to have a transaction get bogged down. There was an act last year that people are interpreting as doing away with the Transfer Act. But the Transfer Act is not gone. At least it's not gone yet. It's still alive and well in Connecticut. What is the Transfer Act as it exists today is what it was a year ago, and actually since 1980. The Transfer Act applies to the sale of any real property or business that generated hazardous waste in excess of 100 kilograms in any one month, hazardous waste that was handled or generated at another facility and stored at the real property. If the property had a furniture stripping operation, a dry cleaner, or a vehicle body repair shop after May 1st of 1967, that would be an establishment. And if you're going to sell either the real estate or the business that engaged in the establishment activities, there has to be compliance with the Transfer Act, meaning one of the two parties to the transaction or even a prior seller has to certify that they'd be responsible for investigating and remediating the site in accordance with Connecticut Department of Energy and Environmental Protection standards. There are a number of exclusions to the Transfer Act. For example, if you have a one-time generation of hazardous waste, that was excluded last year. There are also some transfers that could be excluded from the Transfer Act as well. There's about 30 or plus exclusions to the Transfer Act. So you really do need to analyze and dissect your transaction to determine, number one, is it an establishment? And number two, is it a transfer that's subject to the parameters of the statute?
Right. Yeah, it's an analysis that is can get very complicated very quickly. So you can see why there would be a push to potentially reform it to kind of spur some more economic activity. And can you tell us a little bit about the history of Transfer Act reform and how it got to the point where there's now a perception that the Transfer Act is going away?
Certainly. Um, the Transfer Act is a complex statute, and there have been a lot of questions about how it applies over the years, and you have multiple transactions falling into the Transfer Act process. What you also have is a large number of sites that have historic contamination on them that aren't establishments just by virtue of some of the dates of the operations and when the generation of hazardous waste occurred. The generation of hazardous waste was started based upon when hazardous waste was defined by federal law under the Resource Conservation and Recovery Act. So there's a lot of sites that predated the ability to become an establishment because of the way the law is defined. Every year, it seems there have been statutory modifications that create more exceptions and to try to provide greater clarity. And what that does is make people more confused. There has been an initiative for years by the brokers, by some real estate attorneys, by environmental attorneys, by DEP to try to create a different program that captures a larger number of sites, but also provides some meaningful streamlining. And finally, last year, that occurred with Public Act 20-9. Actually, it was a special act, 20-9. And what that does is sunsets the Transfer Act and instead puts in a release-based program where historic releases and the discovery of historic releases will have to be addressed. The Transfer Act will sunset when this release-based program is in effect. Right now, there's a lot of people working on coming up with what this program is. With DEP, the Act created a working group to develop this release-based program, the discovery of a release, the tiers of a release, what are the reporting requirements for a release, what's your investigation and remedial options. It's a program that is modeled and exists in to be more like other states. For example, Massachusetts has this program. And we'll probably have certainly some differences, but it's just to get at the discovery of historic releases and to take action sooner rather than later. It does not affect or impact work that you will be doing under the Transfer Act until the new program takes effect. But if you are in the Transfer Act currently, you'll still be in the Transfer Act going forward. There's a transition period that will have to occur. The DEP doesn't want to dual regulate properties and dual regulate owners, operators, responsible parties. So there's also the transition piece that is currently being evaluated. And we're waiting for either regulations from DEP or some statutory changes in order to effect an orderly transition into a new program. But the bottom line is, if you're in the Transfer Act now, keep doing what you're doing. Follow the rules of the Transfer Act, remediate the site in accordance with the remediation standard regulations, get your verification in. If you're doing a deal today, you have to analyze in accordance with the Transfer Act. A year from now, if there are release-based regulations in place, maybe we'll have a different program. Maybe it'll be longer than a year from now. We'll just have to wait and see to see what the working groups actually recommend to DEP and then what DEP does with it later.
So it sounds like anybody who's looking to do a transaction that may trigger the Transfer Act in the near term pretty much needs to just proceed as if nothing has changed, because until something officially changes, it's really more prudent to comply with the law as it is, because that's the regime that's currently in place. And even though we currently only have notice that it will change, not that it has changed to this point.
That's absolutely correct.
Great. Well, if people have more questions, they can certainly reach out to any Halloran and Sage attorney, in particular Ann Catino, who specializes in these matters, and we'd be glad to take a look at any individual situations that may require Transfer Act analysis. So thank you very much, Ann, and we look forward to continuing the dialogue.
Thank you, Casey.